So a lot of people have the misconception that testimony of a witness, of a victim is insufficient, and they demand, well, what is the evidence that they have against me? Unfortunately, the testimony of that person, because it can be presented in court and it can be subject to cross-examination, is sufficient in many cases to establish that a crime has been committed and that the person that is being charged is the person that committed that crime. So a lot of people believe that it's going to be inconsequential and therefore I can represent myself. The problem with self-representation is that you will be held to the same standards as any competent attorney with a license in the state of California. So you are going to be going up against, for example, the district attorney's office, who has ample experience. So don't be confused or don't be misled as to that, because it is not wise to represent yourself in a criminal proceeding. Each area of law has a specialization. During law school, we learn a bit about everything. However, what we practice is different than what we study. It is not wise to go to a person who's doing, for example, as you mentioned, personal injury for criminal law, because the navigation of the law is completely different. And so you want someone who is well-versed in criminal law, who knows the procedures, who knows how to maneuver the courts, be able to speak to the district attorney, and know how to negotiate on your behalf. Whereas a personal injury attorney may be able to do that if you had an accident. It's not the same when you're facing charges. And in criminal cases, you're looking at your liberty is at stake. It may be something that is much greater than perhaps in a personal injury case. So what is the role of a witness testimony in criminal court? Witness testimony can be sufficient and may sometimes be the only evidence that the district attorney has against you. The importance of it is, as a defendant, you have the right to have that person come to court and testify. Why? Because that gives you the opportunity not only to observe the witness, their demeanor, the way they speak, have they contradicted themselves, and you can go ahead and use those things that you observe to counter or attack their credibility, thereby making it less likely that the jury or the court will believe what is being said. So what are some misconceptions with regards to self-defense? Self-defense is a way of being able to say, yes, I committed this thing that you're accusing me of, but I had a valid and excusable reason. Not all charges have the defense of a self-defense. So therefore, you have to be careful. But again, you yourself, if you're representing yourself, would not know when and how to assert that defense. So you do need the experience of a criminal defense attorney to be able to assert that defense effectively. If you have any questions with regards to criminal defense, the procedure, the process, or just need to speak to an attorney about something that is happening to you, by all means, please go ahead and give us a call at Confianza Legal.